Αγαπητοί συνάδελφοι, το πανεπιστημιακό τέταρτο δεν τηρείται πάντοτε στα συνέδρια, καμιά φορά αρχίζουν και λίγο νωρίτερα. Αγαπητοί συνάδελφοι, ξεκινάμε υποδεχόμενοι τους ξένους μας, τους καλεσμένους μας, από τους οποίους οφείλουμε να ζητήσουμε όλοι εμείς οι ντόπιοι συγγνώμη για τον καιρό. Δεν είναι συνήθως αυτός ο καιρός της Αθήνας. Προφανώς θα περίμεναν κάτι καλύτερο. Σε μια άλλη τους επίσκεψη τα πράγματα θα είναι καλύτερα. Ευχαριστώ επίσης το Κέντρο Συνταγματικού Δικαίου, το Ίδρυμα Θεμιστοκλή και Δημήτρη Τσάτσου, το Κέντρο των Συνταγματολόγων, που έκανε την τιμή σε μένα, έναν που δεν είμαι συνταγματολόγος, να προεδρεύσω σε μία συζήτηση με θέματα συνταγματικής αναθεώρησης. Αυτό που οφείλω να επισημάνω είναι ότι όσο και από την άποψη του πάνελ, όσο και κυρίως από την άποψη της συμμετοχής, η οποία και μετράει στα συνέδρια και τις ημερίδες, πρέπει να θεωρήσουμε όλοι και να ευχαριστήσουμε το κέντρο και γι' αυτό, ότι η εκδήλωση αυτή πρέπει να λογιστεί σαν πάρα πολύ πετυχημένη. Και πραγματικά τα συγχαρητήρια οφείλονται στο κέντρο, οφείλονται, αγαπητά παιδιά, αγαπητοί νέοι συνάδελφοι, και σε εσάς που με τόση προθυμία, παρά τις αντιξότητες και τις χθεσινές της προσέλευσης και τις σημερινές του καιρού, ήρθατε τόσο αθρώοι να παρακολουθήσετε μια επιστημονική εκδήλωση. Πραγματικά σας ευγνωμονώ γι' αυτό και να ξέρετε ότι μια τέτοια καλή εκδήλωση έχει πάντα ανταπόκριση, έχει ανταπόδοση για ένα νέο επιστήμονα. Χτες, αγαπητοί συνάδελφοι και φίλοι, το μέρος, οι εισηγήσεις, τα αντικείμενα ήσανε πιο θεωρητικά. Δεν πρέπει να λησμονούμε όμως ότι όπως και για κάθε διαφορά, έτσι και οι συνταγματικές διαφορές τελικά λύνονται από κάποιο δικαστήριο. Σήμερα η ενασχόληση είναι με αυτό το πρακτικό μέρος. Δύο εκκλήσεις, ειδικά προς τους νεότερους συναδέλφους. Μην υποτιμάτε το πρακτικό μέρος. Κάθε επιστήμη δεν είναι απλώς μια διανοητική άσκηση. Και ειδικά η συνταγματική επιστήμη δεν είναι μόνον άσκηση πολιτικής. Αποβλέπει και σε κάποιο πρακτικό αποτέλεσμα για την κοινωνία. Στις νομικές διαφορές, καλωσορίζουμε τον πρόεδρο της Ενώσης Συνταγματολόγων, στις συνταγματικές, στις νομικές διαφορές, αυτό το πρακτικό αποτέλεσμα είναι η δικαστική απόφαση. Να μην την υποτιμούμε. Η δεύτερη και τελευταία έκκληση. Δεν πρέπει να απογοητευόμαστε γενικά πολύ αν μια δικαστική απόφαση δεν συμφωνεί με τις επιστημονικές μας ή άλλες μας προσδοκίες. Μπορεί βέβαια ένα δικαστήριο, το όποιο δικαστήριο και ένα συνταγματικό δικαστήριο, να έκανε λάθος. Είναι όμως πιθανότερο, εδώ που τα λέμε, αφού οι δικαστές είναι πολλοί, κάνουν καταπληκτικές διασκέψεις όπου όλα τίθενται, να έχει και δίκιο. Το δίκιο μας, εντός εισαγωγικών, που το βλέπουμε μόνο εμείς, αλλά δεν το βλέπουν τα δικαστήρια, δεν είναι πάντοτε το δίκαιο στο οποίο αποβλέπει η κοινωνία. Θα πω και ένα πρακτικό παράδειγμα και με αυτό θα τελειώσω αυτή τη σύντομη εισαγωγή. Αυτή η απόφαση γνωστή του Συμβουλίου της Επικρατείας, η 668 του 2012, για το μνημόνιο, επικρίθηκε από πάρα πολλούς. Είχε όμως και μια συνέχεια μετά την Ολομέλεια του Συμβουλίου της Επικρατείας, σε άλλο φόρουμ, στο Ευρωπαϊκό Δικαστήριο Δικαιωμάτων του Ανθρώπου. Δεν είναι ευρέως γνωστό, αλλά πρέπει να το πούμε. Το Ευρωπαϊκό Δικαστήριο Δικαιωμάτων του Ανθρώπου στις 7 Μαΐου του τρέχοντος έτους του 2013 απέρριψε τις ενώπιον του αιτήσεις, αυτές που αιτιόντο το Συμβούλιο της Επικρατείας στην πραγματικότητα για την απόφασή του, ως προδήλως αβάσιμες, επαναλαμβάνοντας αυτολεξί σε αρκετά σημεία τις σκέψεις της αποφάσεως του Συμβουλίου της Επικρατείας. Αγαπητοί συνάδελφοι, όσο πιο πολλά δικαστήρια αποτυγχάνουν να δουν το δίκαιο μας, τόσο πιθανότερο είναι να μην έχουμε δίκαιο. Μετά από αυτή λοιπόν την εισαγωγή τη σύντομη, την οποία ευχαριστώ που με επιτρέψατε, εισερχόμεθα στη συνεδρία μας. Πρώτος εισηγητής μας κάνει την τιμή είναι ο κύριος Γιώργ Λούθερ, είναι καθηγητής στο Πανεπιστήμιο του Ανατολικού Πεδεμόντιου, στο Πανεπιστήμιο Αμεντέο Αβογκάντρο. Ο Αβογκάντρο, όπως θα θυμόμαστε, ήταν ένας μοριακός φυσικός διάσημος. Εδώ ο καθηγητής δεν θα μας μιλήσει φυσικά για μοριακή φυσική, θα μας μιλήσει για νομικά, αλλά να μην ξεχνάμε ότι ο Αβογκάντρο ξεκίνησε και αυτός, όπως πάρα πολλοί επιστήμονες όλων των κλάδων, σπουδάζοντας κανονικό δίκαιο. Επομένως, λοιπόν, υπάρχει και αυτή η σύνδεση. Ο καθηγητής θα μας αναπτύξει το θέμα Constitutional Courts in Times of Crisis Mismanagement. Ο κύριος καθηγητής έχει το λόγο.
Thank you very much. It's a great honor for me to speak not on moleculars, more on alchemistry, and not on depths, more on futures. And I apologize because I have to deliver a speech without being able to hear the speeches yesterday because I lost the plane. And I apologize once more because I have obviously limits of competence. I'm just an external observer of the Greek constitutional life. I'm here to learn. And I'm just a lawyer, not a politician. And so take it easy. The argument, the Greek reform hypothesis of a constitutional court demands respect for constitutional identity as a fundamental principle of the European Union, a principle that implies non-interference in national debates on constitutional reform as Greece is facing nowadays. This principle is even binding for constitutional law scholars employed by public universities and implies a duty of academic diplomacy and an aplomb in cases of international conferences upon invitation of the civil society that aim to support the holders of the pouvoir constituant, what you are. On the other hand, constitution making and reform, constitutional change needs comparative law discourses, and similar discourses can be more successful if they are arranged as a transnational dialogue. As a country with an administrative court, but without a constitutional court, Greece has even been compared to the Dutch case. But it is, from my point of view, at least from the point of view of the history of ideas and their potential, virtually much more close to the intermediate model of incidental review. We have the concentrated Kelsenian model and the American model of judicial review. So it is a known model, the Greek one, but more close, I think, to the Italian one that has then inspired in the recent reform of the French system of constitutional justice. If the spread of constitutional courts all over the rest of Eastern and Southern Europe could influence and help to grow a consensus even for a new constitutional court in Greece, Italy could offer so the most closest culture of constitutional justice, and perhaps that's the reason why I'm here. But is it now the right moment, or may we say kairos, for a change of the system of constitutional justice? If we apply the theory of constitutional moments of Bruce Ackerman, it might be the right moment if Greece really needs a new constitution, a completely new constitution, and really is in a state of constitutional failure and paralysis. That is a question a foreign observer, even from Italy, could not be able to give any answer or arbitrate. There are some perceptions of a need for more or less radical constitutional reform, and there's the request of the Eurogroup. Others could invoke the spirit of resilience in Article 110 of the Greek Constitution as a principle to avoid changes under the pressure of times. They could even consider the present situation as a new kind of economical war, detrimental to any constitutional reform. On the other hand, one could use the Greek word of crisis in a way to foresee a revolutionary moment, both at national and at the European level. These are the extremes. In the quite different, but not so far, Italian debate on constitutional reform, I would prefer an intermediate position and play for a minimum revision, just in order to close the so-called transition from First to Second Republic. That's an Italian problem. Jurists tended to look at the Aristotelic middle way. As long as constitutional justice is regarded, Tom Ginsburg holds that politicians are likely to choose a higher degree of judicial review, the higher the degree of political uncertainty at the time of constitutional design is. The multiple crises of Greece and Europe, financial, monetary, economical, political, produces probably a Rawlsian veil of ignorance. But it may raise also the question whether there's any rationale for and benefit from the establishment of a constitutional court. Constitutional economists such as Hayek, Thunberg, Buchanan, Posner are all favoring constitutional justice. But there is no consensus and not yet even an analysis of the economical relevance of the different systems. Hayek was not a friend of Kelsen and preferred just an organ able to resolve conflicts between legislative and executive power, and we will hear about that. Posner preferred judges able to control the reasonableness of lawmakers. So one could argue that in times of economical and financial crisis, both are tasks that could be easier carried out by constitutional court than by the highest courts of the existing jurisdictions. The question has thus be faced through an analysis of the history of constitutional justice on a longer run. My paper is telling the history of the genealogy of systems of constitutional justice at the beginning of the last century. The Weimar Republic doubts it, but we do not know really what is the lesson from Weimar. The Weimar system had a big economical and financial crisis. And the question whether to put in a whether to change from from judicial review that it was established by, created by the highest magistratures, to a constitutional court, or to give to the existing Staatsgerichtshof norm controller, they call it in German, it was quite controversial. It was a social democratic, that's Friedrich Ebert Stiftung, idea for moderated forces, but there were also Marxist resistance against constitutional justice, and that history, I have not now the time to tell it in details. History shows that the constitutional courts served even as watchdogs not only of the parliament. The German constitutional courts is reading the history of Weimar as if it would have a mission to protect the legislator against itself. That is the that's the rationalization of the lesson of Weimar read in Karlsruhe. And that is also used against the Court of Luxembourg. But history shows that constitutional court serves even as a watchdog not only for parliament, but also for the former state of social market economy. If the Constitutional Court is nowadays the authority that reaches the highest public consensus in Germany, the lesson of the history of Weimar could be that the regeneration of confidence through a Constitutional Court is possible, not necessary at all, but possible. So the second and the third chapter, I try very much to summarize. The second story I try to tell you is how does the Constitutional Court in Karlsruhe, the German Constitutional Court, manage financial crisis. There are at least three decisions. One on the constitutional crisis of the land of Berlin after the reunification. The second, the Argentina debt crisis decision. And the third, the decision you all, I imagine, know regarding Greece and the European stability mechanism. You see only the number of these cases that the Constitutional Court has powers that enable the court to be very closed and to decide immediately. And that's the difference between the Northern European constitutional justice systems and the Mediterranean systems. The incidental control is based on a rationale to take time, that conflicts get frozen, are less exciting. That's the Mediterranean constitutional justice. So if you want to have a constitutional court similar to the Karlsruhe one, then be careful. You will leave the incidental model. You will change the model at all. The German way to see it, well, let's decide it immediately because time is money. But that was the conclusion of the German part. The Italian part is much more complicated. Italy is living economic and financial crisis all the time. We had the first crisis in the in the 50s and 60s in Sicily. There has been written a good book of Professor Conchiades over all that stories in all over Europe. The Italian history is much older than it's narrated in the book. It's a history that starts early and that goes on in the 70s. The court was suspected to cause the debt crisis because it was overprotecting social rights. And so I tell you the story how they tried to manage that and the conflicts that were going on. Now coming to our days, the Italian court is often using the argument of financial crisis in order to go into a strict scrutiny of proportionality. But actually, this strict scrutiny of proportionality doesn't give very strong results. Very rarely the court steps into and stops the legislator and the politicians. That is the fact. So it is a rhetoric of constitutionalization of political power in times of crisis, but not much more. Different is the case of Portugal. I would say Portugal is much more active. Is there still time to conclude? Okay. The analysis, so these are the histories I can give you in the detail, tell you in the detail. The conclusions, the analysis of history and present tendencies of jurisprudence show that the hypothesis of a constitutional court for Greece could find new arguments and new expectations. The arguments and expectations depend upon the context. Someone could expect that the Constitutional Court could become a veto player for defense of national constitutional identity at the European Union level. Others could imagine to get a guardian, a sort of Athena, for the defense of fundamental rights against all powers, aristocracy included. Another argument could be the need for the moderator or arbitrator of the new conflicts between politicians or politics and judiciary. The same can be said for conflicts between the central government and local autonomies. Last but not least, the court could be used for procedures of self-defense of democracy against old and new enemies, including extremist political parties. That is the menu. That is what we can choose in order to give powers, the competences we can give the Constitutional Court. In any case, the Constitutional Court is an instrument to get stability and to regenerate trust and confidence in all our rights and powers. In a democracy, that would mean not self-sacralization, but self-confidence of the persons and of the politeia, and a minimum hope of republican resilience. That would be the banner. That is a good goal, especially in times of crisis. But the question is, how many powers needs a constitutional court in order to manage it? As constitutionalism needs a good mix of idealism and realism, we should immediately warn that the Greek Constitutional Court could not enter in a competition with Karlsruhe, but it could develop itself an increasing power. Take it for longer times. Start with a little bit one. It will increase its own power. It's a common European experience with constitutional courts. All depends from the choices of the institutional skills that have been already outlined by the Venice Commission, especially the question of individual access to the court and of the recruitment of the personnel. It is not the task of this paper to enter in that field, but just to draw some general conclusion. First, the creation of a constitutional court would not be the only constitutional reform to carry out. If there is a consensus that this is not the moment to change the whole constitution, it could be useful to combine the creation of the Constitutional Court with other more reforms on more technical aspects of what Italian doctrine calls the maintenance of the book of the Constitution. That should be a more technical adjustment of the Constitution. Don't take it so dramatically, would be the first conclusion. The second conclusion is that within the court should be no majority, neither political nor technical. The separation of powers needs to be reflected in the structure of the organism. Otherwise, it could be accused to realize juristocracy and technocracy, or to be just a mean for the survival of political parties. That's the second conclusion. The third conclusion is that the court can just participate to a transnational dialogue, not reproduce symbolically national sovereignty. No constitutional court will ever have a last word, being the last word in any constitutional state reserved to the people as a pouvoir constitué. Thank you very much.
Ευχαριστούμε πάρα πολύ τον καθηγητή Λούθερ για την ανάπτυξή του. Αγαπητοί συνάδελφοι, φαντάζομαι ότι διερμηνεύω την αντίληψη όλων ότι επρόκειτο για μία πολύ ψύχρεμη και διεισδυτική ανάλυση που ελάχιστοι Έλληνες θα μπορούσαν να την κάνουν για την Ελλάδα. Πάρα πολύ ψύχρεμη και πολύ διεισδυτική ανάλυση με κέρυες επισημάνσεις που πρέπει να ληφθούν υπόψη από όλες τις πλευρές σχετικά με την ανάγκη αναθεώρησης του Συντάγματος στην παρούσα περίοδο, ποιας αναθεώρησης και ειδικά σε σχέση με τη συνταγματική δικαιοσύνη, ναι ή όχι και με ποιες προϋποθέσεις ένα συνταγματικό δικαστήριο. Επίσης, πολύ ενδιαφέρουσα ήταν και η οικονομική ανάλυση της συνταγματικής δικαιοσύνης, την οποία υπενήχθηκε. Πολύ ενδιαφέρουσα η σύγκριση μεταξύ των νότιων συστημάτων που χαρακτηρίζονται από μία ραθυμία στην αντιμετώπιση και των βόρειων συστημάτων που χαρακτηρίζονται από μια βιασύνη που ίσως ορισμένοι την έλεγαν υπερβολική, άλλοι θα την έλεγαν ταχεία απονομή της δικαιοσύνης. Πάρα πολύ ενδιαφέρουσα ανάλυση. Ευχαριστούμε και πάλι τον καθηγητή. Και τώρα στην επόμενη εισήγηση η κυρία Σοφή Μπουρόν, που διδάσκει στο Πανεπιστήμιο του Μπίρμιγχαμ, μια Γαλλίδα που διδάσκει στην Αγγλία, βρίσκει την ευκαιρία να συνδυάσει τις δύο αυτές ιδιότητες και να μας αναπτύξει το θέμα Constitutional Review in France and the United Kingdom, the comparative interest of anti-models. Η κυρία Μπουρόν έχει το λόγο.
Thank you, Chairman, for this very kind presentation. Good afternoon. Okay. The debate in Greece, I'm told, when I was invited for this conference, turns all around constitutional reform, and more specifically, my brief was all about the introduction of a constitutional court. Now, I've got to admit, I feel a complete fraud here. I was very skeptical when I received this very gracious invitation. I accepted it. But I have to say that both the UK and France have got a typical system. And I thought, if I'm supposed to be talking about this, to actually help Greek constitutional lawyers with a possible reform for a Greek constitutional court, this is going to be terrible, because they're going to be more confused about this than anything else. So I decided, well, I'll try to find a way to make this work. One way of making this work is, rather than using, as we sometimes do in comparative law, the idea of model, i.e. you look at a court, you think that would be a good match for your own constitutional order, and you try to replicate it. I thought the best thing to do here would actually to think about anti-models. Not that I think the UK and France have models which don't work. They work very well in their own system, but I don't think they could be either transplanted or copied or imported. However, you can learn even from things which are not models. You can learn by looking at the various problems that they have. You can learn at the structures that they've used, the reason why this system were adopted in this way. So you take a step, a little bit abstract, a step back. But there'll be plenty of down-to-earth analysis. Don't worry about that. So the talk will be in two parts. In order to be able to explain why I have, what I can say about the Greek Constitutional Court, I'm going to first present very briefly the UK system and then the French system, and then I'll make my comparative analysis. I will draw lessons from these. The UK, well, you'll soon realize that I was a bit surprised when I was asked to talk about the UK, because there is no constitutional review as such in the UK. There isn't a constitutional court, and there is no constitutional review. Why is that? And actually, the why is that is quite interesting. The reason, they're basically two, and they're all to do with the Constitution, the British Constitution. Some of it we've already discussed yesterday, for those of you who were there. We're here. The nature of the Constitution, there's two aspects to this Constitution which is problematic for constitutional review. A, the British don't have a codified Constitution. I prefer the term codified or uncodified rather than written, unwritten, because actually quite a lot of the British Constitution happens to be written. It's just not codified in a single document. The second obstacle is that it's a very political constitution rather than a legal constitution. It's not completely true, but the British do put quite a lot of emphasis on the political character or nature of the constitution. That's very important for them, and I think they do have a point. A constitution is actually a dialogue between its political constitution or component and its legal component. Now, it's true that in the last 10 years, the legal constitution has started to take quite a lot of importance in the UK, but there is a resurgence of the supporters of the British Constitution, and I think that's quite important. So that's another reason as to why there is no constitutional review. Another reason why there is no constitutional review in the UK is that the content of the Constitution itself, the principles that are contained in the Constitution, makes it difficult. I'll give you two examples of that, only two. I haven't got enough time to explain that. The first one, there is no recent Declaration of Rights in UK law. The British Constitution doesn't have a Charter of Rights or any sort of rights protection which is endogenous to the British Constitution. And that's a slight problem. The second is that the British Constitution has a key principle, a keystone of their Constitution still, is a principle called parliamentary sovereignty, or parliamentary supremacy, as some of us actually prefer. That principle basically places Parliament at the top of the constitutional arrangements. It's the keystone of the British Constitution, and one of its main principles is that it prohibits court from challenging statute, acts of Parliament. And that makes it quite problematic to actually implement constitutional review. In addition, and that follows on, the courts have an inferior position in the constitutional order and in the political system. So it also makes it difficult for a constitutional court to arise. Finally, and that's important for what I'm going to say later on, that principle of parliamentary sovereignty also dictates a system, a dual system, when it comes to international treaty, which means that any international treaty which has been signed will need to be incorporated in an act of Parliament prior to having legal effect in the UK. So this is parliamentary sovereignty, and even though it's a principle which is a bit on the wane at present, it still remains an extremely important principle in the UK. So, as a result, there is no constitutional review. That doesn't mean there is nothing to say about this in the UK. There is something called the Human Rights Act. In 1998, the Labour government passed the Human Rights Act in order to incorporate the European Convention into English law. And that's exactly what happened. And not only that, it's very interesting because it has been very original in the way it implemented that convention. What it does is that it tries to mix political remedies with legal remedies in order to work with the difficulty created by the principle of parliamentary sovereignty. And I think that's quite an interesting idea. The first thing it does, it creates an environment of compatibility. So it tries to avoid the existence of incompatibility, and it does it in two ways. It makes a duty on public bodies to comply with the convention, with one exception, and that exception is Parliament. So Parliament is legally entitled not to comply. And then in Section 19, it creates a political mechanism by which minister goes before Parliament when it's debating a new bill, and the minister will declare or not whether the bill complies with the convention or not. And the great majority of cases, the minister has been able to say that that bill complies. So it tries to create an environment of compatibility. And then if that fails, there are remedies. And there are two types of remedies. There are the legal remedies, and that's the court has a duty to interpret any legislation, subordinate or primary, in light of the convention, so make it compatible even when there is a difficulty. And if that's not possible, and sometimes it does happen that it isn't possible, legislation says as far as that's possible, then there is a political remedy. What happens, what I would call a political remedy, what happens, the court makes the declaration of incompatibility. They tell the Parliament that there is a problem, that there is an incompatibility, but that incompatibility stays. The act remains in force until Parliament decides to do something about it. So that's the that's the judicial review in the UK. Now, France. France is also a very odd system. Why is it an odd system? Well, it started very similarly to the UK in 1958. Our constitution dates from 1958. And it started very similarly. We had no protection of rights, and arguably we still don't. And there was an official rejection of constitutional review. The drafter that made it very clear that the point of that new institution called the Constitutional Council was not a standard constitutional review mechanism. All it was meant to do was to basically protect the executive from the incursion of Parliament, is basically what they were doing, making sure of. And that was it. That was not at all, constitutional review was not on the cards. However, that changed quite quickly. 20 years later, or less than 12 years later, the Conseil constitutionnel did two things. In one decision, it incorporated or integrated a number of texts in the Constitution, which were all Declaration of Rights or List of Rights, and then it decided to check the statute against these rights. Quite revolutionary, if you think about it. But it wasn't terribly commented on at the time. A bit, but it certainly did not make... it wasn't regarded to be a huge revolution. Now, let's look at very quickly what the system is in 1958. What was the mechanism in place? The mechanism in place was meant to respect the will of Parliament. Exactly the same. I mean, there are echoes with the British system. And in order to do so, the Constitutional Council only intervened a priori. That means that once the text, either a bill or a standing order or an international treaty, had been adopted, then it would be forwarded to the Conseil constitutionnel for control. Nobody waited for it to be implemented and problems to arise. It was all done prior to having legal effect. And in terms of treaties, it also meant that if the treaty was found to be unconstitutional, it could not be ratified until the constitution had been amended. So, quite important. There are two types of control, just briefly. Compulsory, all the texts are sent to the Conseil constitutionnel when they're standing orders and when they're organic laws. Organic laws are those which implement the constitution. And the referendum resulting from popular initiative, this is a more recent addition. And they're optional when it's ordinary statutes, ordinary laws, and treaties. And in that case, the people who sent those texts to the Conseil constitutionnel for control are all politicians. So it's a very political control. It's the President of the Republic, the Prime Minister, the President of both chambers, and 60 members of one of the chambers, the two chambers. And that's basically it. The problem with a system like this is that it created gaps. It was felt that it did not cover all the potential inconstitutionality, and so recently, in 2008, we've adopted a new procedure, which I translated as procedural preliminary ruling on the question of constitutionality. And the idea was to strengthen the rights of citizens. What happens now is that under some conditions, which are listed there, individual applicants who believe that a provision which is applicable to their case is unconstitutional can refer it or can ask that to be referred to the Conseil constitutionnel. And then the Conseil constitutionnel rules on it, and then that ruling is then applied back by the ordinary courts. I won't go through the conditions. They're there. They're not terribly exciting, and they're not terribly useful for my purpose. So that's the French and the British system. What am I going to learn from that? Well, there's two things I'm interested in. First of all, setting the scene for the reform, the sort of prerequisites of the reform, all the questions we need to ask, even before we ask about the type of design we're going to give the court, and then the content of the reform itself. Setting the scene. Well, there's two things that I can say about a positive and then more specifically what we're going to do. A positive is that if Greece wanted to actually adopt a new constitutional court, this amendment procedure should start from a position of strength. There's already constitutional review in existence. It's not as if you're creating something new, it's there. So as far as resistance, it shouldn't be too much of a problem. And there is a fantastic constitutional protection of fundamental rights. It's one of the best ones. So I think you start from a position of strength. Now, the prerequisites, all the things that I think need to be decided even before we go further. Well, the first thing we need to know is whether we should amend or not. One of the things I've got to say about that is normally, and the French system will be a good highlight of that, normally when one needs to amend, it's because there's a gap, there's a problem, there's a weakness, there's a bit of an urgency about it. Now, I know there is an urgency of different type. I'm not convinced that there's an urgency with regard to the Greek Constitutional Court. That's what I'm saying. Especially paradoxically, because you already have a diffuse review of a diffuse system of constitutional review. So I'm not completely sure that that's going to happen. I've got to point out, in 2008, the reform was adopted because it was part of a large program of modernization of the Constitution. I'm not convinced it would have been adopted on its own. In fact, I have evidence it wouldn't have. It failed twice before. And it only happened in 2008, A, because I think it was included in a wider change of the Constitution, which was necessary, and two, that reform only passed by one spare vote. It was not very easy. So, another one is constitutional timing. Constitutional timing in Greece is not underestimated. It's part of your thinking of the constitutional amendment. So, that's no problem. However, what I'm slightly worried about is twofold. The first is that constitutional timing needs to work with political timing, and that's quite difficult to make it work together. And I'm concerned about that. And political timing is absolutely fundamental to get the success of the reform. Another aspect of timing, which is more long-term, I would be concerned in engaging in a process which, because it's a process of change, is risky in itself. A status quo is less risky. Changing always carries some degree of unknown and some degree of risk. I.e., what I'm saying is that the constitutional order would be a bit more vulnerable. It's not a great achievement, especially when the situation is already fraught. The economic situation is already quite complicated. And I'm worried furthermore with this question of timing, because constitutional courts tend to result in high-profile, contested and controversial cases. Now, and they are quite condensed, so you have quite a lot of high-profile and contested cases. I would be worried that this would end up being quite divisive and destabilizing in its effect. So I would be worried with the timing. My last point, which is not worried at all, but I can't answer because I have no knowledge about Greek constitutionalism. The French and British system clearly show that both of those systems were matched to a specific understanding of constitutionalism, of French constitutionalism and British constitutionalism. I don't know what the tenets of Greek constitutionalism are, but I think they need to be really unearthed and used in order to provide a Greek constitutional court which would match whatever constitutional tenets you have. And I think that's just a general statement. Now, the content of the reform. Issues of institutional design first, whether old or new. There are two ways of going about this reform. Either you completely get rid of your diffuse review, your diffuse system of constitutional review, or you create a court which works with it. That's two possibilities. whichever way you're going to go, you're going to have your ordinary courts and your ordinary Supreme Courts. I know ordinary Supreme Courts is a terrible concept, but what I'm trying to say is that you're going to have the Supreme Courts which exist already, your Cour de Cassation and your Conseil d'État, to work with a new court. Now, that might seem completely normal, but in France, it has been absolutely disastrous. We've had terrible tension between the courts and infights of quite a high level. It has calmed down a bit, but that's something that I think very few expected to be so hard. That they expected some difficulty, but not that much. And I think this is important that the new procedure takes into effect these potential new tensions. And I'm not sure whether I would go all new or whether I would try to marry the old and the new. I certainly would be very concerned in stripping the ordinary courts of all their constitutional review powers. I think that would be absolutely disastrous. But I don't know, after all, I know nothing. My second possibility is whether you should go a priori, a posteriori, or both. The advantage of going a priori is that you could marry the a priori system with your diffuse system of constitutional review. That could work together. So that's a possibility. My last point with this part is appointment and membership, and I think it's actually the most difficult. Most constitutional courts' legitimacy will rely on two things. They will rely on what I would call legitimacy of outcome, how good their decisions are. That I can't predict, and neither can you, I suspect. However, part of legitimacy will be on the appointment system and their membership. Who sits there, who they are, how they are appointed. Some people believe, but I am not one of those people, that memberships and appointments systematically find its way into the outcome. I'm not convinced with that, actually, but I know that there's plenty of people who believe this, and I am in the minority. However, those two questions are important and for some are linked. It's very important that the legitimacy of appointment is protected simply because you're going to have you may have a lot of very contested or divisive decision to make by that court. So that's extremely important. Now, having said that, that doesn't mean that you should go what a lot of reaction would be to juridicialize that court, to make it very legal, to have lots of judges, to have lots of legal expertise. Both the UK and France, and the UK should be left out because it's not really constitutional review, but France has a very political constitutional council. And it may be a bit too political. I'm not saying that it's necessarily a good thing, but I think it's important to have a mixture of the legal and the political. And it's a difficult articulation to have, and the legitimacy of it is not easy, but I think it's quite important. I certainly wouldn't go all the way of the French people, or the French example, because the French anti-model, and it really is an anti-model for that, doesn't even require legal qualifications of the members of the Conseil constitutionnel. So you could have a chemist, and there was a chemist, who was a member of the Conseil constitutionnel. So, I wouldn't necessarily go all this way, but that's an important aspect. Having a lot of ministers or past ministers on the Conseil constitutionnel is something that the French have had. More than half of them were past ministers. And I won't defend the past president of the Republic, because that's not defendable. But we have plenty of these, officially. Right, last 2 points. I'll be quick. It's important also that whoever is going to be thinking of this court, think about how they're going to interact with the European courts. The reason, in a practical basis, the reason I'm saying that is that we've had difficulty with the Conseil constitutionnel and the European Court of Justice. 2 ways. The time limits are very, very short, and it's very difficult for the Conseil constitutionnel to refer anything to the European Court of Justice. And that's a very practical issue, but it has actually quite difficult and important ramification of relationship between the courts. In fact, the Cour de Cassation tried to create difficulty between the Conseil constitutionnel and the European Court of Justice by sending a reference to the European Court of Justice, accusing the new procedure not to comply with the treaties and Cimental. But the European Court of Justice cleverly managed to sidestep the problem and to support the Conseil constitutionnel, who has now sent a reference for the first time, and it was done within the time limits, it was all working. But the reality is that it's very tight in those circumstances. Abdeli, yes, exactly. So that's something that I don't think many people thought about when they drafted that procedure, but I think that is a serious issue. The last one, which will also play part of the conclusion, is that my impression, and it's very impressionistic, but my impression is that when there is a constitutional reform of courts, when we talk about reforming constitutional review, very often we trigger more dramatic changes than we think. And often we enter a dynamic of constitutional change. This has been exemplified both in the UK and in France. So it's positive and negative. It's positive in the sense that maybe by just changing the court, you might be able to engineer much more changes that you would want without too much, without going necessarily into strict constitutional reform. At the same time, and sometimes it happens, that dynamic ends up feeding itself in the way that we lose control. That's my last point and my conclusion. I thank you very much for your kind attention.
Ευχαριστούμε πάρα πολύ την κυρία Boyron για την εισήγηση αυτή. Αυτή η εισήγηση ήταν χωρισμένη στην πραγματικότητα σε δύο μέρη. Στο πρώτο μας έδειξε γιατί η μάχη, και αν δεν υπήρχε, έπρεπε να την ανακαλύψουμε. Μας έδειξε δηλαδή την πολύ μεγάλη διαφορά δύο συστημάτων που χωρίζονται από μία λεπτή λωρίδα θάλασσας, του γαλλικού και του βρετανικού, όπου αυτό θα πρέπει να το συγκρατήσουμε. Στο βρετανικό σύστημα το παν είναι το κοινοβούλιο. Αυτή είναι η εξουσία. Στο γαλλικό σύστημα ελέγχου συνταγματικότητας των νόμων, τα ακούσατε, μπορεί ο καθένας να συναγάγει τα συμπεράσματά του. Όσον αφορά το δεύτερο μέρος, ήταν πάλι μια εξαιρετική ψύχρεμη και αντικειμενική ματιά από το εξωτερικό, μια τεχνική συμβουλή, αν θέλετε, υψηλού επίπεδου για το πώς πρέπει να σκεφτούμε στην Ελλάδα όταν συζητούμε για τη μεταρρύθμιση του συστήματος ελέγχου της συνταγματικότητας των νόμων. Ας τους ακούσουμε καλά πριν να είναι πολύ αργά. Σκεφτείτε λίγο στην Ελλάδα ένα συνταγματικό δικαστήριο την παρούσα περίοδο της έντασης που θα αποτελείται από πρώην υπουργούς. Σκεφτείτε τι βαθιά εμπιστοσύνη θα υπάρχει στον πολίτη ότι οι αποφάσεις του θα είναι δίκαιες και αμερόληπτες. Σκεφτείτε το λίγο, σας παρακαλώ, στην Ελλάδα σήμερα.